Good morning, everyone, so you don't hear me double. And welcome to this colloquium discussing the future of animal law in South Africa and where we wish to head and move, and a discussion of some of the proposals that have come up through this engagement project that has been taking place over the past 2 years. My name is David Bilchitz. I'm a professor at the University of Johannesburg, at the University of Reading, and director of the South African Institute for Advanced Constitutional Public Human Rights and International Law. And I'll be chairing a lot of the conference and look forward to engaging with all of you who are in this room and also those of you who are not in the room and are joining us virtually. Now, this is frozen. Okay, there we go. So the first order of business is to say thank you to all the people who've been involved in putting this together, from the project organizing team, Humane World for Animals, to Tony, to Karen, to Tawat, to Animal Law Reform South Africa, to Michaela, to Cheslin, to Melanie, to Tokyo, and a special thanks to Amy Wilson, the Executive Director, who's really gone the extra mile in getting this together in a relatively short time. And then from my own team at SAIFAC to Naomi Hove, I'm very grateful for her involvement as well. University of Johannesburg, as you'll see, this conference facility, our students are doing the catering. So we're grateful to be here. And as I will introduce soon, we're very delighted and grateful for Justice Jody Collipins giving us the keynote address. And I will introduce him more fully a little bit later. We also thank all the speakers, local and international, who are going to be taking part in this colloquium, and everyone who has participated thus far in the Animal Law Project and has given input. And thank you to those who are attendees as well. So as I mentioned, the Animal Law Project is a collaborative effort initiated by 3 organizations: SAIFAC, the Animal Law Reform South Africa, and Humane World for Animals, formerly HSI-Africa, who focus across areas of fundamental rights, justice, animal law, animal welfare, and animal protection, respectively. Animal Law Reform South Africa is South Africa's first and only dedicated animal law non-profit organization. Humane World for Animals is a global animal protection organization working to help all animals, including animals in laboratories, animals on farms, companion animals, and wildlife. And SAIFAC, the institute I direct, is a leading research center in South Africa, producing advanced research in its focus areas. And I should just say that the output, the actual manifesto that you see, I could not be involved with the drafting or the final development thereof because of my stint as an acting judge at the Constitutional Court. It was inappropriate for me to be involved in that effort. So I was involved in the beginning stages, and then the product you see was not the product of my engagement directly, although we've had discussions around things involved with some of the issues. And that was really the result of the collaboration of HSI and ALRSA, Amy and Tony, who put their heads together with a group of experts as well. So I want to start with the famous "I am an African" speech by Deputy President Thabo Mbeki at the time on the passing of the South African Constitution. And he said the following in a poetic speech: "At times and in fear, I have wondered whether I should concede equal citizenship of our country to the leopard and the lion, the elephant and the springbok, the hyena, the black mamba, and the pestilential mosquito. A human present amongst all these, a feature on the face of our native land thus defined, I know that none dare challenge me when I say, I am an African." Now, in this quote, Mbeki suggests that a defining feature of Africanness is sharing the land with other creatures. He conjures up an ethos, not of domination, but of mutual respect and cohabitation with others. Indeed, far-sightingly, he suggests the conferral of equal citizenship upon non-human animals, a suggestion that was much more recently only defended in academic literature in a fantastic book called Zoopolis. African societies have lived with animals, and it's important to return to this ethos that was challenged by colonialism. The relationship between animals and humans were often shaped by a sense of harmonious relationships being created, an ethos of Ubuntu with other humans, non-humans, and the environment more generally. Unfortunately, that understanding was not really included in international law and the domestic law in many countries, which saw animals effectively as commodities. And the key question for South Africa, after rejecting the system of apartheid and creating new foundations for our legal system, would be in this sphere, what is required by the new South Africa, by the new constitution, to transform our relationships, not only with humans, but also with those who are not human, who share this country with us, but have a different form, are part of a different species. Now, the final constitution of 1996 established the foundation for the new South Africa. It was established on basis of fundamental principles and values of human dignity, equality, freedom, and it's the supreme law that shapes all other law. And to be valid, all law and conduct must be consistent with it. It's enforced and upheld by our courts, including at the apex of that system, the Constitutional Court. The state and corporations must respect, protect, promote, and fulfill the rights. And there's also a duty to consider in the interpretation of legislation and the development of the common law that every court must engage with the spirit, purport, and objects of the Bill of Rights. The Constitution speaks in its preamble of we the people of South Africa believe that South Africa belongs to all who live in it. United in our diversity does all include those creatures who share South Africa with us. The goal of protecting the vulnerable in our society. And in fact, we know at the time of the Constitution drafting, there were a large number of representations to include the protection of animals in the Constitution. However, unfortunately, there's no express mention of the protection of non-human animals in the South African Constitution, except in the schedules dealing with the competences of national government and the provinces. That, of course, does not mean that animals are excluded from protection. And the question arises concerning the implications of the Constitution for animals. As I mentioned, the new constitutional dispensation fundamentally shifted the South African constitutional order. And so this is a vital consideration to consider in what our legal framework must become given the constitutional shift. Now, we have a top constitutional judge with us, so I'm not going to preempt the presentation of our keynote speaker, who I'm sure will engage more with the case law and very much of the elements that he has been involved with as well. But I think for our purposes in this introduction, a critical impetus for law reform in South Africa is the Constitution, which requires a fundamental rethinking of the approach adopted under apartheid and colonialism towards animals. And as such, we need a new law that properly articulates and enshrines the new constitutional ethos within our own law. Now, there are many other impetuses that have led to a drafting of an animal welfare bill, right? This is not a question that we've just undergone in the abstract. There is a new animal welfare bill that's currently being drafted by the Department of Agriculture. That is a fact, okay? And the socioeconomic impact assessment study in 2018 focuses on national strategic benefits of modernized animal welfare legislation. These include better animal productivity and health, better food safety and security, and an enhanced ability to access international markets for animals and animal products. The latter issue relates particularly to gaining access to international markets, including the EU, which requires a higher standard of animal welfare. Now, I think it's important to recognize that this motivation, the main motivation articulated by our government, does not place South Africa as a leader in the field. It rather sees us as simply falling into step with other countries, following their lead and being driven by their imperatives, such as the EU. South Africa, however, has resources in its own right to be a leader in this area rather than simply being a follower. Moreover, the study frames the protection of animals in terms that are purely instrumental for human benefit. Animal welfare is only included as so far as it advances anthropocentric aims, economic interests, human health, and economic development. Now, of course, another impetus for the shift in animal welfare law is a change in science. The Animals Protection Act was drafted in 1962, obviously has had some subsequent amendments. It's based on older legislation on animal welfare. And the scientific understanding of animals, their sentience, their consciousness, their value has shifted, okay? And we'll explore some of this in the first panel. Social science has also shifted, where there's much research demonstrating the intertwining between actions that humans have towards other humans and animals. In fact, I was fortunate to supervise a PhD who looked at the relationship in domestic violence against animals and how that's a predictor of domestic violence against women and children, what's often called the link. And so in a society that is very violent, we need to consider what is being done in relation to other creatures because there's an intertwining of the relationships. Okay, and that will be explored in the first and fifth panels tomorrow. There's also the environmental and climate emergencies, which are also, of course, a major impetus for this. There's increasing recognition of human interdependence with other beings and the environment due to this crisis. And we've seen how rampant exploitation and pollution harms ourselves. And we have a right in our Constitution, Section 24, to the environment. And again, I will leave that, no doubt will be explored by our keynote speaker and other speakers in relation to how the environmental right impacts in relation to driving law reform. So why the Animal Law Project? The Animal Law Project ultimately is focused on transforming animal law protection legislation in South Africa as a constitutional imperative, rooted in social justice, rooted in the changed understanding of animals in social science and general science, and also looking more generally at the interrelationship between humans, animals, and the environment, seeing us as connected, as part of one system, rather than as seeing one part dominating fully over the others. The new law should be rooted in the Constitution, recognizing the positive link between animal interests and human rights, looking at South African values and considerations and developments in scientific knowledge. It should not arguably reinforce colonial ideals, non-transparency, non-accountability, the domination of the strong over the weak, environmental irresponsibility, and other harmful practices. And so a process was undergone when we knew that there was going to be an animal welfare bill that was being considered by the government and redrafting to create an animal law project, okay, which would essentially create a platform to engage with law reform. And there's been an ambitious attempt to consult with the animal protection community, which has many, many organizations across South Africa, and with over 100 organizations making submissions. Surveys were sent out to various organizations, webinars and conferences and colloquium were held. There have been engagement with people who are experts in animal law, in science, etc. And ultimately also there's been a desire to reach out to the government and bodies such as the NSPCA, etc. And so there has been a real attempt to engage across the sector and to essentially hear what people have to think, because something like law reform in this area needs the experience of a wide range of organizations that have been involved in the sphere. And that led to the creation of a manifesto as a key step in this regard. The manifesto identifies deficiencies of the current legal framework. It sets up certain foundational values and principles, and it also lays out some core principles and enablers that should be taken account into the law. And it's recognized that that document, which many of you now have, right, and I'm sure most of you have seen, and it's now been printed, and you're welcome to get a copy if you don't have outside. That's a starting point. It's ultimately an engagement point for consultation, for discussion, before essentially finalizing more detailed proposals for what should go into a draft law. And many hundreds of individuals and dozens of NGOs have already said that they buy into the general principles of the manifesto. There's been also some critique of the manifesto, and that's all welcome. And that is part of the reason for this colloquium today. that we will, in fact, explore some of the key themes underlying the manifesto. There'll be various panels which will put it in input. The goal is to gather key input from stakeholders who care for the protection of animals and to build on existing ideas and develop them, as well as to generate new ideas. So as I said, we will actually create a law which South Africa can be proud of, can also be leading, as I said, rather than following in the sphere. A decent life for those other creatures that we share our society with. We also are welcoming very strongly participation. And while there's a lot of speaking, and there's a lot of fantastic people here who can provide input, it will be really important that there have been spaces left on the program for discussion, for inputs, for concerns, for queries and critiques. And all are welcome and encouraged. So that lays the scene a little bit for our colloquium today. But as I said, given the view that the Constitution, in our view, is the main impetus for law reform, gives me very great pleasure to introduce Constitutional Court Justice Jody Colloquium as the keynote speaker for this conference. Justice Colloquium has a long history of human rights activism and involvement in advocating for social justice. He, in fact, practiced as an attorney and joined the organization Lawyers for Human Rights in the early 90s. And in 95, he was appointed the national director of LHR. And during that time, he was also appointed by the late President Mandela to the selection panel that recommended commissioners for the Truth and Reconciliation Commission. Judge Colloquium, also many people will know him from his time as well as the chairperson of the South African Human Rights Commission from 2002 until 2009. He was also there, appointed as a judge of the High Court in the Gauteng division since 2011. He was also the chairperson of the South African Law Reform Commission, and he has served as a justice of the Constitutional Court of South Africa from January 2022. Justice Colloquium has also served on the boards of several public interest organizations, including the Legal Resources Center, the Center for the Study of Violence and Reconciliation, and the Institute for Democracy in South Africa, and Article 19, based in London. Now, as a High Court judge, and more recently, actually, in a interesting constitutional court case about actually human rights of privacy versus freedom of expression, Justice Colloquium has engaged with a number of cases of constitutional significance, which relate in some ways to animals and the environment in many ways. And he's shown himself as a leader in this area. And apart from his other fantastic engagements with the rest of the South Africa's constitutional jurisprudence. So, Justice Colloquium, we're really grateful you accept this invitation, for your time. We know you have a court hearing tomorrow, and without further ado, I'm going to hand over to you for the keynote address. Thank you very much. Need to switch this off. There we go.
I assume this must stay as is, not so. That's fine. Otherwise I won't be seen. So, good morning, and thank you very much for inviting. Sorry, I've just got something in my throat. So, is this water? Thank you. That's fine. So thank you very much for the invitation. I'm honored to be here, and I'm somewhat intimidated because I'm in a group of people whose expertise in this area far exceeds mine. I've written 2 judgments that relate to animal welfare. The one involved the export of lion bones, and the other was a privacy versus freedom of expression case, but it involved the trapping of baboons and their killing. And that featured tangentially in the case, but became quite a significant feature after that in the case, in weighing up how one reconciled, as it were, the right of freedom of expression as opposed to the right of privacy, and the question of ownership of animals and other yours, the things and the law of property, etc. So it had relevance there. I'm aware that there's a law reform process underway to develop a new law with regard to animal protection. And at the outset, just 2 quick observations: that the outcome of that law and the process are both critically important. The process is important because our constitution is committed to a system of participatory democracy, but more particularly in the context of the process that will lead to the adoption of a new law. There's provisions in the Constitution that provide clearly for public participation. And I have no doubt that you will take the fullest advantage of that opportunity. But just to indicate to you that in many law reform processes, certain voices are heard. And very often they are the voices of people who are resourced, NGOs are resourced, academics. And there's nothing wrong with it. But often the ordinary voices of people are not brought to bear in the lawmaking process. And so down the line, it doesn't help too much to say, well, we've passed a law, and this is the extent of the public participation, but the large majority of South Africans were excluded. So I'd like to urge you in your public consultations to also take that into account, to take into account the diversity of who South Africa is, and to try and ensure that space is made for those voices to also be heard. They may be voices that differ from yours, but I think that process is important because often one finds that, in particular sitting as a justice in our court, the public participation process in Parliament is often characterized by limited public participation, really those who are resourced, those who know the law. And I'll come back to that point just now. The second important part of the process is the outcome. And as David has mentioned, the outcome is relevant for two reasons. The one is that all law and conduct must comply with the Constitution. So whatever law is finally passed must be tested against the Constitution, and it must comply with the Constitution. Is something that we can discuss later, but we'll also debate that. Must it comply with Section 24, or must it comply with a number of other provisions in the Constitution? Must it comply with some of the values in the Constitution as opposed to some of the rights in the Constitution? And I'll touch on that briefly. But more importantly, I think the outcome of that law will be reflective of what we say about ourselves as a society, who we are and what we stand for, and what are the values that would shape, as it were, that law. It's simply, I think, not a case of the law complying with the Constitution, important as that is. I want to argue that beyond that, the Constitution consists of a set of values. And those values are critical, even if they're not legal rights, but they're critical because it defines really who we are. And I want to touch a bit on the difference between a rights-based society, which we take great pride in, but a values-based society. A rights-based society may be the exclusive preserve of lawyers. A values-based society extends beyond that. And for me, that's much more important, and I think we often avoid that. And so, given that David has said so much that I want to say, let me start with, he's touched on what former President Mbeki said, and I want to start with what former President Mandela said when he signed the Constitution in law. And this is the kind of society that he contemplated. And this is what he said very briefly. And so it comes to pass that today South Africa undergoes her rebirth, cleansed of a horrible past, matured from a tentative beginning, and reaching out to a future with confidence. So that's the society that former President Mandela described when he had in mind what this new constitution would say and what it would do. And in saying that, one may then ask the question, which I think many people will ask: what has animal welfare and animal protection got to do with the Constitution? Because, as was pointed out, the Constitution is expressly silent on animal welfare and protection. However, various schedules to the Constitution deal with issues like animal control and disease, agriculture, nature conservation, abattoirs, and in the context of provincial versus national versus local legislative competence. And some would say, well, if there's no constitutional standard with regard to animal welfare and protection, then what's the debate around? And what's the bar, the benchmark we set in the lawmaking process? Now, I'm aware that some of the debates and discussions may go beyond what you will talk about today. Professor Bilchard's using the twin concepts of legal personhood and dignity. And please forgive me if I don't summarize this correctly, David. It's argued that animals are bearers of rights, even though they may not hold legal duties. He's also argued that the concept of dignity is something that is not confined to human animals. It's argued that non-human animals also have a right to have their dignity protected. And if I understand him, his conclusions correctly, he argues that this rights perspective would be the proper conceptual basis for animal law reform in South Africa. I may have a view on that, but it might not be wise for me to express my view, because I have no doubt that that issue may well come before our courts in future, but it's an important issue. The other approach would be that, well, Section 24 of the Constitution recognizes the right to an environment and creates some obligations. And to the extent that our courts have located animal welfare and protection within the right to an environment, that would form the basis then for animal law reform. So they are conceptually quite different. But the outcomes, the different outcomes could be quite different and quite far-reaching. Because on the one hand, if you're located in a recognition of rights, then the whole legal framework is different, because you recognize that animals have rights, and therefore the limitation of those rights kick in, the extent and the scope of the protection of those rights kick in, as opposed to locating it within Section 24, which some may argue continues to see animal welfare in terms of its benefit for human animals. And that's the limiting part of that. And I'm not sure if that debate is going to be resolved in the course of this process. I don't think it will. But I don't think it should go away either. And without wishing to give you any advice, I think it's important to put that debate in the public domain. And even if it doesn't get resolved now, it stays there, and it's important for us to reflect on that. And so just briefly touching on why is it not in the Constitution. We looked at what happened during the Constitutional Assembly process about 30 years ago, in 1995. And there was something like 17,000 petitions received by the Constitutional Assembly. There were numerous submissions made by animal groups alliances, the Animal Anti-League Cruelty, the NSPCA, organizations like Beauty Without Cruelty, etc. And all of them were located on a similar idea that animals were sentient beings. And most of them sought to argue for the inclusion in the Constitution of a clause dealing with animal welfare and protection. Not in the context of a rights-based clause, but of a duty-based clause. And the one formulation which was suggested at the time was that, and I quote from that, all persons have the duty to ensure that all animals are treated in a compassionate, dignified, and respectful manner without the infliction of stress or suffering, and that they're able to satisfy their basic needs and natural instinctive behavior. And there was an alternate formulation. In speaking to people close to the process in the last few days, I tried to establish why, despite the sort of strong public support for the inclusion of, in the then Section 23 of the Constitution, a provision at least dealing with animal welfare, it didn't see the light of day. And there were different arguments given. The one was that going back to the schedules, it may have been a question of provincial versus national versus local. But I don't think that's convincing, because I don't think you could include that, and that would undermine the provincial. You could have a general in the Constitution that says that you have a duty to treat animals in a dignified, compassionate, and caring way, and then say, well, different spheres of government will have different responsibilities. But the argument must be that they all must comply with that constitutional standard. The second argument, which may have been more probably convincing, not necessarily acceptable, but understanding what happened in 1995, was that there would be strong lobby groups and interest groups against its inclusion. Because once you create this duty, how would courts interpret it? Could you trust courts to interpret them in a way that sort of balanced out properly competing interests? And the third argument was that there was a clock ticking to finalize the Constitution. There were various issues on which the parties needed to reach agreement on. And this one would have been unlikely to have reached a state of sufficient consensus. And therefore, it didn't find itself in the Constitution. But if we now today, as David has challenged us, saying, well, the Constitution must form the basis for the law reform process. Well, what in the Constitution must form that basis? And I want to make the argument that if we look for a right only, we might limit ourselves in finding a proper basis. And we need to look more carefully at the values that underpin the Constitution, just not as found in the Constitution, but in the manner in which our courts have used those values to interpret rights. And that's important. And let me start with an observation that I think I've made before, and it worries me. Because in the early 90s, when we contemplated the birth of a new society, former President Thabo Mbeki said, some people look forward to the future with hope because of what they hope it must deliver. And others look to the future with fear and uncertainty because of what they think they may lose. And sometimes it seems we are stuck in this uncertainty between hope and insecurity. And it seems what has happened in our society is that we've become a society of rights bearers and duty holders. And I don't think that's what the Constitution contemplated. The preamble to the Constitution speaks of a society, not a group of people holding rights and responsibilities, but of a society committed to social justice, democratic values, and fundamental human rights. And the two things that emerge from that for me is the idea of a society. A society means people, their environment, and those beyond their humanity being connected, and interconnectedness. And secondly, the idea of democratic values, for me, is different from the idea of democratic rights. Because if they are the same, the Constitution wouldn't speak about values and rights differently. Let's take an example. The idea of social justice is the idea that the goods in the society, commodities in the society must be equitably distributed. But the idea of equality doesn't necessarily equate the idea of social justice. So in our context, we allow people to accumulate as much wealth as they wish or as they're able to. You may ask, well, is that consistent with the idea of social justice? I don't think it is. But I'm not sure if you can challenge the accumulation of wealth on the basis that a right in the Constitution conflicts with a value in the Constitution. And so it's much more comfortable to talk of a rights-based society and a rules-based society. For one, it provides for certainty. But two, it also allows us to actually not reflect on ourselves in this values-based society. Because everybody says, I have a right And once you establish that you have a right, no one can say anything else. So cabinet minister would say, I have a right to drive a 2 million rand car. And you ask them, well, is it consistent with the values of a society committed to social justice? And they say, well, why do you take the debate there? That's not where you take the debate. I have a right. And that's what we do. And everybody has their favorite right as well. But we don't talk about the values underpinning our society. And I think because it's difficult, and because in a society that is as unequal as ours, when we speak of a values-based society, most of us, if not all of us in this room, will be on the wrong side of that equation. I mean, we don't experience the kind of inequality that millions of South Africans experience. And I'm often reminded of a trip I made many years ago when I was the head of the Human Rights Commission to a little village called Hapasha, which is deep in Sekhukhune. It took us about 4.5 hours to get there. And when we got there, the villagers were sort of pleased to see us. And after I'd spoken about the Constitution and human rights, an elderly villager got up and he said, I enjoyed listening to your talk. You speak with so much passion about this thing called human rights. I thought, well, that sounds great, but I knew something was coming. And he said, but if you'll allow me to make this observation, that when I see the way you're dressed and the car you've driven here, this thing of human rights has certainly worked for you. But if you see the village in which we live, and it was evident, you'll accept that it hasn't yet worked for us. And you'd appreciate that we're not as passionate about it as you are. But we can assure you that one day, when it works for us, we'll be just as passionate, if not more passionate than you could ever be. And I think that's the challenge of South Africa. You know, we say to people, this is our constitution. We must defend it. It took many lives and hundreds of years of struggle. And I often ask, if someone says, this has been my existence for the last 30 years, and this has been the existence of my family, my community for the last 100 years, what is it that I must defend? And I think we need to find the proper answer to that question. And for now, we're not doing all that well because we are consistently the most unequal society in the world. And so you may then wonder, what has value-based society got to do with the topic? And I think it has everything to do with the topic. Because if we look at what are the values we want to advance as a society, and our courts have helped us with that. In the well-known case of Makwanyane, Justice Mohammed, and I think that's not correct. It would have been Mohammed DP at the time, wouldn't he? Deputy President of the court. Chaskelson was the president, right? Spoke about a commitment to a democratic, universalistic, caring, and aspirationally egalitarian ethos, which is what he understood was being articulated by the Constitution. And so that characterization of the Constitution as being more than simply a set of rights and obligations and rules that govern our interaction encompasses a value, for me, must serve as an important base as well, together with Section 24 in this law reform process. Because I think it's an opportunity to speak to society beyond animal welfare and protection when one harnesses the idea of values. It will also be an opportunity, I think, to attract more interest in the debate, because many people, and I must confess to you, this is the first time I've spoken at a conference or at a meeting around animal welfare and protection. You must take responsibility for not having invited me earlier. But maybe you'd say, well, there was nothing that you did earlier that warranted an invitation. And that's fair. Because I think when we see it in separate silos, then we fail ourselves. Because I often say, well, how do you rear a generation of children to be caring and compassionate towards each other, when at the same time you condone actions and conduct in a society that's violent towards animals. It's simply inconsistent. And so, moving on then, please just let me know, Lula, will you tell me if I'm running out of time, because I sort of just haven't followed the flow of what I've written down. And talking about this universal caring society, our courts have invoked this value base in interpreting rights. It did it in the case of Grootboom, where it invoked the value of human dignity in dealing with what would be the reasonableness of state conduct in discharging its obligation, the right to provide housing. It also did it in the context of the right to property. In the Port Elizabeth municipality case, where SAIFAC said the following. It might be worth just reading these 3 or 4 lines. We are not islands unto ourselves. The spirit of Ubuntu, part of the deep cultural heritage of the majority of the population, suffuses the whole constitutional order. It combines individual rights with communitarian philosophy. It is a unifying motive of Bill of Rights, which is nothing if not a structured, institutionalized, and operational declaration in our evolving new society of the need for human interdependence, respect, and concern. I mean, these are wonderful words, but they're absent in the way in which we connect with each other, in the way in which we relate to each other. And so, moving then on to Section 24 and a rights-based coupled with a values-based approach. The Constitutional Court, as well as the SCA and other courts, have located animal welfare and protection within the parameters of Section 24. However, Section 24 provides for a duty to protect the environment for the benefit of this generation and future generations. Someone may argue, well, again, it's a provision that sees animal protection in terms of human benefit. And the linkage is there if you interpret it that way. However, it's capable of being interpreted in a wider sense, that the benefit of future generations is just not for the benefit of those who are considered human, but for the generations of humanity and everything that encompasses that. And so it may well be a useful basis on which to proceed. Although, as I've said earlier, I think the argument that Professor Bilchitz has raised is a critical one moving forward as well. And I have no doubt one would be able to get there. And over time, our courts have then taken a different approach to animal welfare and protection. In one of the earlier cases I read, State versus Smith, that dealt with animal protection. A dog owner had pelted his dog for about half an hour, beaten the dog, and then finally shot the dog in the kennel. And the court said, hold on, you know, it's your property, and you can ultimately kill it if you wish to. I mean, that's problematic itself, but we'll come to that. But please do so humanely. So this idea of the humane treatment then began to evolve over time, but in a very contradictory way. It almost said, well, there are no rules to decide when you kill your animal. But like, if you do so humanely. And I've read somewhere that someone said, well, look, while they're living, let's treat them humanely. But, you know, once we take the decision to kill them, I mean, then we can kill them. And I'm not sure if that's going to be resolved in this process. I don't think so. But it's an important ethical issue. It's an important values-based issue. But in any case, our courts have described animals as sentient beings. And what does that mean, sentient beings? The Buddhists say, well, sentience is consciousness. The Sentience Institute says, well, sentience is the capability to experience pain and joy. And the argument then is that all sentient beings are entitled to be treated in a humane way because they're capable of. Interestingly, I read, and it may be, I haven't been able to verify it, but there are two animals that fall outside being sentient. So it's oysters and silkworms, because they don't have a nervous system. I don't know if that's true. It may well be that whoever did the research on that had a penchant for sort of oysters and silk scarves. I don't know. And so was able to justify eating oysters and wearing silk scarves. But in any case, that's because there was no central nervous system, and therefore you were not a sentient. And so our courts have done a few important things. They've located animals in an understanding that they can feel pain, joy, suffering. Secondly, they've located it within Section 24 of the Constitution. And thirdly, and importantly, the Constitutional Court in NSPC versus the Minister of Justice made, I think, the very important point that we do it not for our benefit, but because animals have an intrinsic value of their own. In the earlier cases, we sought to prohibit cruelty because it offended the finer sensibilities of being human, whatever that may mean. And so there's a useful base and there's a useful starting point. We need to be careful, though, and I may have been guilty of this myself. When I wrote one of the judgments in the 4 judgments that the Constitutional Court produced in the recent case of Botha versus Smuts, there were 8 judges and 4 judgments. But in any case, that case involved the trapping of baboons on a farm in the Eastern Cape, where a farmer had laid some traps and put some oranges in. There was a dispute whether the oranges were poisoned or not, but they lured the baboon into the trap and the baboon couldn't get out. And there was a debate as to how the baboon finally died, whether the baboon died from eating the poisoned oranges, or the farmer said, hold on, once the baboon is trapped, the farm manager would come around later and shoot the trapped baboon. In any case, in the course of reading the expert reports in that matter, I was quite fascinated by what happens when a baboon is trapped. What happens to the rest of the troop? They become distressed. They undertake attempts to rescue, even if they injure themselves in the process. And if the trapped baboon is a leader of the troop, it results in aberrant behavior amongst the troop. And it struck me, like I'm sure it might strike many of you when we see a chimpanzee on our TV. We say they're so very much like us. And the fact that we have between 94 and 98% common DNA should be an issue of little importance, isn't it? And I'll tell you why. Because in my mind, I saw the danger of me creating a hierarchy as well within the animal world, like we do amongst humans. We see those who are very much like us are entitled to equality, and those who are less like us. So when it comes to gays and lesbians, we are less likely to extend to them the protection of the right to equality, or migrants or refugees, but we say those who are like us. And so we mustn't fall into the same trap and say those animals that are closer to us are worthy of greater protection. If they are sentient beings, and if as a matter of right, not as a matter of benefit to us, they are worthy of protection, then they should be entitled to that protection. And the point has been made earlier that other jurisdictions have also undertaken some kind of recognition. The EU has done so. The Constitution of India has a provision that deals with the treatment of animals. But if truth be told, our story of humanity has been a story of progress on the one hand, but it's also been a story of massive and wanton destruction against the animal world. Most of it unjustified. When we co-opt them into our wars, we use them in order to test the best beauty products so that we can reverse the irreversible process of aging. In India, some animals are revered, but not all. But again, it's because we select them. So okay, we'll revere the cow, but we'll slaughter and we won't eat the cow. And I was surprised when I went to India. I thought they all, vegetarian or largely. But I mean, pork is consumed in large quantities. So we do it again for our own benefit, and we see them as instruments towards our own advancement. And so in that regard, maybe and I'm not sure if I know the answer yet, but David has challenged us. How can we be the leader in this field? But what would it take to be the leader? What would distinguish our laws from any other laws? Certainly saying animals have rights would distinguish it. But I don't think we're going to get there, in this round at least. But I think this provides us with an opportunity to do something comprehensive, because we come across animals in very different contexts: farming, experimentation, law enforcement. I was the victim of an animal in a law enforcement operation. I'd gone to Uganda. I think I can share this with you confidentially. And I'd love the plant, the banana, the green banana. It's when it's fried, it's beautiful. And my host then, on the way to the airport, stopped at a roadside stall and bought a couple of kilos and put it in my overnight bag. When I got to our Tambo airport, I was waiting for my luggage to come off, and my hand luggage was on the floor. And the police dog came and sniffed it. The guy said, "What do you have in there, sir? Do you have drugs or anything like that?" I said, "It's just bananas." He said, "Sorry, we've got to confiscate it." And that was it. But so we transport animals, and we see the conditions under which they transported on road, on sea. And so some guidelines, some standards around that. But I think they must all link and derive from a common base. And I think that common base is something where we as South Africans can distinguish ourselves from the rest of the world, to provide a substantive rights/value-based base. And that could be useful because it could provide, as it were, the basis to hold all future law to a sort of common value base. And I like the way you do the three things. You do intrinsic value, sentience, and the third one is constitutional values. Right. So that's great. So let me conclude by wishing you well. I think this is such an important initiative. But I also think that most of South Africa at this point in time doesn't see its importance. And so I think you have a twin responsibility. The one is to be focused and dedicated in terms of the outcomes of your law reform process. And you may have to be strategic as well. You may have to put some demands on the table simply to discount them at a later point so that you get what you actually want. Don't quote me on that. But I think that's a strategy you might have to. We're not going to achieve this, but hey, let's ask for it, because we will get something less than that. Secondly, is to find ways to expand this discussion. I found an interesting thing that the Department of Basic Education puts out on constitutional values for governing bodies and for schools. And I'm wondering whether some discussion around values would be important. How do we deal with the slaughtering of animals for food? I mean, that's the slaughtering of animals for customary purposes. I mean, those are difficult issues that we have to navigate, but we have to do so. And we may not get there now, but I think this is an important initiative, and I want to wish you well, and hopefully I will continue to follow what you do. I used to be the chair of the Law Reform Commission, but it may be useful to also engage with the Law Reform Commission. And Ronelle is here from the Law Reform Commission, who worked closely with me on that project. But more importantly, more recently, she's worked on a project looking at litigation in terms of health litigation. You know, healthcare litigation costs the country billions. And I'm not sure if all that money gets to the beneficiaries. So Ronelle is looking at some of that. So thank you once again. And yeah, I still have lots of stuff in there, but it's okay. I wanted to. Yeah. Okay, thank you. Okay.